It is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. This is the subcommittee's fifth hearing in as many months regarding the Voting Rights Act. Voting rights is an important topic. No one disputes that, but we're wondering when we'll take up other important issues under the jurisdiction of this subcommittee. So today's hearing will focus specifically on the practice-based coverage provision in H.R. 4. I'm going to put this very simply. This overly broad and constitutionally suspect Democratic proposal aims to outlaw common sense voter integrity measures. Under the practice-based coverage regime, every state and political subdivision would have to pre-clear certain election practices, including changes to voter identification requirements and simple changes to voter registration list maintenance processes. This is a draconian step, and let's just be honest here, it's a clear attempt to federalize elections. As I've noted here many times before, the election clause of the U.S. Constitution gives state legislatures the authority to prescribe, quote, the times, places, and manner of holding elections. Voting is a fundamental right in the United States, and the 15th Amendment requires the states to ensure voting is accessible and available to every American. Congress passed the Voting Rights Act in 1965 to overcome state resistance and barriers that prevented minorities from exercising their right to vote, as is guaranteed by the 15th Amendment. But this was during the Jim Crow era. As Chief Justice John Roberts stated in Shelby County in that opinion that we talk about so often in here, the, quote, exceptional conditions at the time justified the, quote, extraordinary departure from the traditional course of relations between the states and the federal government. But that was at that time. In the same opinion, the court found the Voting Rights Act coverage formula to be outdated, finding that, quote, the conditions that originally justified these measures no longer characterize voting in the covered jurisdictions, unquote. If the record today does not support a new coverage formula, it most certainly does not support the sweeping practice-based coverage preclearance provision found in H.R. 4. One of our witnesses today, Mr. Russ Nobile, aptly concluded that if nationwide registration disparities did not justify nationwide preclearance coverage when the Voting Rights Act was originally enacted, it is very difficult to see what data from today supports imposing it now. This legislation is just another example of a politically motivated power grab that will enable partisan federal bureaucrats to control state election laws. We will likely hear from the other side of the aisle this practice-based coverage provision is needed because states have come up with innovative ways to, quote, suppress minority voters. That's all we hear about today. But that is a false and patently absurd argument. Today, it is easier for eligible Americans to vote than ever before in our nation's history. And to be clear, Republicans want every legally cast ballot to count. But the only way to make sure legal votes carry the weight they deserve is to prevent casting of illegal votes. One common sense way for states to do this is through voter ID laws. But under practice-based preclearance, states and political subdivisions would have to go to Biden's Justice Department or the courts to enact a simple voter ID law. Mandatory voter ID is an election integrity proposal that is very popular across the nation because it follows logic and common sense. A recent Monmouth poll found the overwhelming majority of Americans, 81%, support voter identification laws, including 62% of Democrats who participated in the poll. Furthermore, 34 states currently have some form of voter ID law on the books, and this includes many liberal states with provisions nearly identical to the ones Democrats are criticizing in the state of Georgia. H.R. 4 is wildly out of step with the facts on the grounds and with public opinion, and we should be considering ways to empower states to secure their elections rather than subjecting them to the whims of President Biden's radical bureaucrats. I do thank our witnesses for appearing today. We look forward to your testimony. I see we have students or interns here. We're glad you're here as well. Thank you, Mr. Chairman. I yield back.